I was digging through some old Boston court records late last night, as one does when you can't sleep, and I ran into a case from 1846 that made me stop and squint at the screen and read the damn page about 3 times. Now, we all know lawyers will try just about anything to get a client off the hook. That ain't news. But what this fella pulled off in a 19th century courtroom might be the single cleanest piece of legal audacity I've ever seen in my damn life. The story starts in October of 1845 in a quiet little neighborhood in Boston. Early one morning, neighbors start seeing smoke pouring out of a boarding house on Mount Vernon Street. People run in with water buckets, put out the flames, and inside one of the back rooms they find a woman named Maria Bickford. She was dead, throat cut ear to ear, and someone had tried to burn the evidence by torching the mattress. Didn't take the local constables long to figure out who was in that room last. Maria had been seeing a wealthy young wild child named Albert Tirrell. Albert had a wife and kids back home, but he'd walked away from all of it to run around the city with Maria. They argued, they made up. On this particular night, half the neighborhood saw Albert slipping into a room. By the time the fire was put out, Albert was gone. He didn't just step around the corner either. This man fled Boston, headed south, made it all the way down to New Orleans before the law caught up with him. They threw him in the chains, shipped him back to Massachusetts, and put him on trial for capital murder. In 1846, if you lost a capital murder trial in Boston, you didn't go to prison. You walked up a wooden gallows with a rope around your neck. Albert's family had money, so they hired the best attorney in the state, a man named Rufus Chakotay. Now, Chakotay had a mess on his hands. The physical evidence was brutal. The bloody razor belonged to Albert. The cane left at the scene belonged to Albert. The man ran halfway across the country the moment it happened. Any normal lawyer would have tried to claim self-defense or blamed it on a mysterious stranger. Well, instead, Rufus stood up in front of that court and delivered what the court files called a defense of somnambulism. Yeah, I ain't even going to try to say that bullshit $5 word again. It just means the man was sleepwalking. Rufus looked 12 cold-faced New England jurors in the eyes and argued that, yes, Albert was in the room. Yes, Albert held the razor. And yes, Albert set the fire. But he was fast asleep the entire time. He brought in witnesses who swore that ever since Albert was a little kid, he'd get up in the middle of the night and do crazy shit. He'd walk into walls, yell at ghost figures, trash his room, wake up the next morning with zero memory of any of it. Rufus' argument was that Albert had a night terror, grabbed his razor, slit Maria's throat, set the bed on fire, put his hat and coat on, walked out the front door, and took off for New Orleans. All while he was dead asleep. And here's the absolute weirdest part of the whole damn thing. The jury actually believed him. After 2 hours of deliberation, they came back with a verdict of not guilty. Rufus literally convinced a jury that his client committed a horrific murder in his sleep, and the state of Massachusetts let the man walk out a free man. Old court files are full of strange things, but an 1840s lawyer convincing a court that sleepwalking excuses a bloody murder is right up there at the top. Pull up a chair next time, judge the files for yourself, and remember, believe nothing, question everything.